Okay, we're going to go ahead and get started. First off, my name is Morgan Guerrero. I am the Administrative Operations Manager here on the Pacific InterWest Apartment Inspection Services team. I'm joined today by our report writer, Sarah Chen, who will be jumping in to lead a part of our webinar a little bit later. Today we are going to be talking about the SB326 law. We're going to go over where it came from, what it requires, all the specifics that can potentially be a little bit confusing. So our goal here today is that you'll leave with a better understanding of what SB 326 means for you and any properties that you might own or manage, and that you'll understand the terms and the definitions that are all throughout the law so that we can all be experts by the end of this. Just a quick rundown of what we're going to go through today. So I'm going to start with a little bit of background on how SB 326 came about, go over some legal requirements and definitions and the inspection process. And then Sarah's going to jump in and walk through what you can expect in a completed report, as well as some practical field examples and some examples of some local enforcement. And then I'll jump back in at the end to go over some common misconceptions that we run into. And then we'll have time for a quick Q&A at the end if anybody has any questions as we go along. You will see the Q&A chat. You should see that at the top of your window. So if you have any questions throughout, feel free to throw them in there and we'll get to those at the end. So before we get started, just a quick introduction into who we are. Pacific InterWest has been performing building inspections throughout California for many years, about 20 years. We've completed probably thousands of SB 721 and 326 inspections. So we've had the opportunity to work within a lot of different jurisdictions and cities throughout the entire state. So diving right into some legislative background, the origins of the SB 721 and 326 law starts with the Berkeley balcony collapse in 2015. There was a gathering out on a balcony at the Library Gardens apartments in Berkeley that the balcony had collapsed unexpectedly. That did result in several casualties. And the building at the time was only about 8 to 10 years old. So this was an unexpected failure of the balcony that launched an investigation into what could have happened, what could have caused it. And investigators found that the issue was not due to the weight on the balcony of having multiple people. It was found to be the result of some pre-existing dry rot caused by years of moisture intrusion. And by the time the balcony failed, the structural framing had deteriorated so badly, and you can see how severe the damage was here. So as a result of that, Berkeley created its E3 inspection law, which predates the statewide SB 721 law for apartments, as well as the SB 326 law for condos. And since then, there have been a few updates here to the legislation. You can see the timeline here, such as expanding on who can legally perform the inspections, some clarification on when the same company can both inspect and repair the same property. One thing that is very important to note, though, is that while SB 721 did receive an extension to the deadline for their initial inspections, SB 326 did not. So the initial inspection deadline for SB 326 was met on January 1st of 2025. We will have a specific SB 721 webinar a little bit later down the line to go over all the details pertaining to that. So now we're going to go over some legal metrics about SB 326. SB 326 applies to condominium properties. These inspections are to happen every 9 years, and the inspection sample size uses what's called a statistically significant sample. We'll talk a little bit more about what that sample size actually looks like a little bit later. SB 326 is a statewide law with enforcement falling to more local jurisdictions. Cities and counties are permitted to add additional requirements on top of what's already written in the law, but of course they cannot remove any of the guidelines that are already laid out within SB 326. So now we are going to work on defining what qualifies as an exterior elevated element under this SB 326 law. So an exterior elevated element, or an EEE as it's commonly shortened to, can include any of these elements that you see listed here: balconies, porches, stairways, landings, walkways, etc. But the characteristics that would define an element as an EEE are that it must be weather exposed or outdoors. It must have a walking surface that is 6 feet or more above the ground. It must be designed for human occupancy, and it must rely heavily or entirely on wood for support. Now, this does include the metal elements with attachment points that are into wood support. So metal railings that would be attached to any of those balconies, stairways, etc., and also full metal EEEs that are attached into wood for support. Some people might assume that because the element is entirely metal, that SB 326 wouldn't apply, but that's not necessarily the case. If there's wood framing involved, or if the waterproofing protects underlying wood structural components, then it would in fact still fall under the SB 326 law. Within an SB 326 report itself, there are a few required elements. You must include a total inventory of all EEEs in the report, whether or not all of the elements are being inspected. You must include that total inventory. The report must, of course, include the condition of all the inspected elements. Photos are specifically required as a part of the SB 326 report, which is not the case for SB 721, but it is for SB 326. SB 326 reports must then be shared with the HOA's reserve study, and they must also be made available to homeowners. As far as who's permitted to complete an SB 326 inspection, it must be done by an architect or a civil or structural engineer, which is a bit more restrictive than who is permitted to complete an SB 721 inspection. As you can see, the formula there that's used for calculating the statistically significant sample, with X being the total number of elements of a particular type. And we'll have some examples of that later, so you'll have a better understanding of how that applies. As far as our actual inspection process here at Pacific InterWest, what we first do is collect all the pertinent information about the property from the client, and then we will use that information to put together a proposal and calculate that statistically significant sample size. And then we will randomly choose which individual elements to inspect. The tenants are then notified on based on the needs or requirements of that particular property or city, whatever the jurisdiction outlines. And Pacific InterWest, we are able to provide a template that clients can use for this notification if needed. Then the on-site inspection is performed. The inspector will take their photos, notes, moisture meter readings, etc. For closed soffit elements, holes will be drilled into the element and inspected with a borescope camera. For open soffit elements, that isn't necessarily required because you can see all of the structural components of the element without doing any drilling. When we do have those drilled openings, those openings can then, based on client's preference, either be patched or they can be used to install puck vents. And the advantage of the puck venting is that they promote airflow, which can reduce future moisture buildup and thus reducing the potential for future damage. The inspector will then, of course, they'll write up all their findings and send it to our report writing team so we can begin putting together that report for the client. When the inspector finds damage or issues at an element, they generally fall into one of two categories. Non-emergency repairs are not specifically mentioned in the SB 326 law, but when it comes to immediate hazards, there are, of course, some requirements. The property owner is notified immediately, and the local authority having jurisdiction must be notified within 15 days of discovery. Emergency repairs must begin immediately, including preventing any occupants' access to that element. And now I'm going to go ahead and hand things over to Sarah, who's going to start by going over some field examples.
Thank you so much, Morgan. So for this section, we will be going over examples of damage seen by inspectors in the field. So this was an immediate hazard caused by unchecked water intrusion. The dry rot was so severe that the stucco was splitting from the posts and the beams. Now, this is an example of guardrail damage that looks minor, but is actually fairly dangerous. It can cause water intrusion, which then causes interior deterioration. Additionally, loose guardrails in general are just safety risks. And as mentioned before, all guardrails are subject to inspection, even metal. So this is a damaged waterproof coating at a balcony surface. This damage we would consider minor, but keep in mind that this is minor damage as we go to the next slide. So the minor damage from the start, because it was never addressed, allowed unchecked water intrusion to cause severe staining. And additionally, you can see dry rot beginning at these edges. So this is dry rot that this is dry rot that is deceptively simple, but is actually a severe issue. So due to damage at these structural connection points, we would consider these a fail. And this is the importance of having a professional inspection because they can tell and see the difference between a scary pass or a discrete fail. And so this is what we would consider a scary pass, but it is not a fail. As you can see, the beam underneath is still intact, and the joists appear to be securely attached to an inboard ledger. This is what we consider unique damage. This was unreported walking surface damage caused by a tenant. And additionally, I have seen other examples of damage that was unreported, such as a hole that was burnt through a deck but covered up by a rug from the tenant. So additionally, this is another example of unchecked damage caused by inadequate monitoring of a post near landscaping. Draining water and termites at the soil led to this extreme damage you see here. And as you notice from this children's bike underneath, ignoring issues can lead to irrevocable tragedies. Now let's talk about what should be in an SB326 report. The inspector's signature or stamp is always required. Same with SB721, but we will go over that in a later SB721 webinar. Additionally, 326 requires a stamp from either an architect or a structural engineer. Finally, that report needs to be sent within 45 days of inspection completion, but PIA aims for 2 weeks or less. A report needs a description and photos of each element type inspected because it gives a clear baseline between now and the reinspection in 9 years. When PIA finds issues, we do include recommended repairs and an estimated lifespan between now and the reinspection in the future. For example, 8 out of 9 years. For any immediate hazards found, we will attach the additional documentation that is required. Finally, miscellaneous materials such as asbestos tests will also be included. This is the exterior elements matrix that PIA attaches to every report. The purpose is to provide all necessary info about an element at a glance. Not seen, however, is a column with a link to an individual report. for an element with more granular details. Finally, unique to PIA, we can issue a report addendum stating that repairs were made at the property. We just require proof of those repairs, such as photos. Once you have the report, here are the next steps you need to take. Keep it on file and submit to the city if necessary. If minor issues were found, we recommend the property owner complete repairs, but this is not required. If we find fails, we highly suggest retaining the services of an architect or an engineer to draft plans before finding contractors to submit plans for the city for permit and then to actually carry out those repairs. Again, however, this is not required by law. However, if we find an immediate hazard, legally it will be reported to the city and repairs will be required. The following are examples of repair plans, and PIA can also help with repair design. Now we move to local enforcement and the unique ways city enforce this law. First of all, the state sets general requirements, but ultimately enforcement is left to the authority having jurisdiction, the AHJ. Under SB 326, the AHJ is allowed to recoup the cost enforcement from a property owner. In Fremont, a website with educational material was created, and an online portal was created for property owners to submit reports. Fremont also requires fees to submit, which helps fund their program. As you can see, this is an example of their website. Now, Berkeley, as mentioned before, created the E3 program. It requires that metal-to-metal elements also be inspected, which is an example of adding to state requirements. There is a website with educational content and an additional form that must be submitted by the inspection firm. Again, the forms and the educational website. And again, more educational material by Berkeley. This is where, to round off our discussion of local enforcement, however, we thought it'd be prudent to mention a similar law that predates even E3. SF 604 includes metal elements that are not included in the SBs, such as fire escapes. An SF 604 inspection does not cover SB requirements, but it is important in its own right. At a somewhat recent combined SB and 604 inspection we did, there were only minor issues under SB requirements, yet the property failed 604 because a fire escape that had loose bolts created a hazard that could have caused a ladder to fail in an emergency. Again, the affidavit that must be submitted to the city. And again, this is what I mentioned earlier on. The state sets the general terms, but details funding specific processes are left to the AHJ. And at a minimum, the city creates a place to store complete inspections, but the state doesn't give any direction on what to do with the report after it has been completed. They just require the property owner to keep it on file. So now I will be turning things back over to Morgan for our FAQ.
Wonderful. Thank you very much, Sarah. So yeah, now I'm going to go over some common misconceptions that we often run into in all the years that we've been doing this. One misconception is that duplexes would require SB326 inspections. The answer is no. Even if there is an HOA that's made up of a large group of duplexes, the law only requires individual buildings with 3 or more dwellings to be considered as relevant. So while duplexes are often considered properties, oftentimes it's important to think of this law on a building by building basis. Another misconception is that drilling is only required if a visual inspection reveals any reason to be concerned. While this can be true for elements with open soffits, if you're working with a closed soffit element, drilling is required in order to view the structural components in order to satisfy the SB 326 inspection. And another misconception that we've seen is that hiring the same contractor to complete both the inspection and perform repairs is more cost effective. While this can be perfectly legal under the guidelines of the laws, and there are, of course, contractors with the integrity to navigate this process fairly. It's not always more cost effective because it's usually best to keep these rules separate to avoid any potential for an inspector to perhaps embellish on their findings and create more potential revenue for themselves. A big misconception about SB 326 is that 100% of the exterior elements need to be inspected. While this can be the case, it isn't always. For example, we're using that statistically significant sample formula that we have here, with X being the number of elements of a particular type. So for example, if you have 10 elements, then your sample size would be those entire 10 elements. If your sample size is 40, if your total elements are 40, your sample size would only be 37. And with an element count of 150, your sample size would only be 109. And it's important to note that each element type, balconies, walkways, stairways, etc., would be calculated separately using this formula. The intention with SB 326 is that eventually all of the elements will be inspected. So if elements are not included on the initial inspection, they would then be inspected when it comes time for your next round of inspections in 9 years. So if anybody has any questions, we'd be happy to answer them now. Otherwise, if you have any more specific questions, maybe about a property that you own or manage, or if you're looking for any SB 326 or SB 721 proposals or inspection information, we would be happy for you to reach out to us. Our contact information is on the screen there, as well as a QR code that directs to our website. You're more than welcome to reach out to us, and anyone on our team would be very happy to help you out with any information that you might need. And if there are no questions, we thank you so much for joining us, and we hope everyone has a wonderful weekend.